As the battle over the Waqf Act 2025 intensifies, the Supreme Court finds itself at the heart of one of the most sensitive legal and constitutional debates in recent times. Today marks the second day of hearings on a batch of petitions challenging key provisions of the Act. But what exactly is waqf-by-user? Why is the court contemplating an exception to its usual reluctance in staying laws? And how has this legal storm triggered violence on the streets of Bengal? Let's break it down. The Supreme Court on Wednesday made it clear it is seriously considering staying certain provisions of the recently amended Waqf Act 2025. Chief Justice of India Sanjiv Khanna, leading the three-judge bench, remarked, and I quote, "We don't usually stay laws at this stage, but this might be an exception." Waqf by user refers to land used for Muslim religious or charitable purposes for a long period and hence treated as waqf property, even if not officially registered. CJI Khanna observed that scrapping this idea could have huge consequences, especially for properties dating back to the 14th and 15th centuries. He acknowledged misuse exists but added there is genuine waqf by user too. You can't say it doesn't exist at all. Solicitor General Tushar Mehta defended the law, stating that registration of waqf properties has been mandatory since the first Waqf Act of 1923. According to him, even waqf by user must be registered. Nothing prevented anyone from registering since 1923. But the court pushed back, questioning how ancient religious structures could produce modern documents like sale deeds. Another controversial provision gives district collectors the power to declare disputed land as government property, effectively stripping it of waqf status until a court rules otherwise. The court seemed uncomfortable with this clause, suggesting that while the collector may conduct an inquiry, his conclusions should not have immediate legal effect. The court also questioned the inclusion of non-Muslims as nominated members on Waqf boards, stating only ex officio roles should be open to non-Muslims. Any other appointment may violate religious autonomy under Article 26. Senior advocate Abhishek Manu Singhvi, arguing for the petitioners, pointed out that nearly half of India's 8 lakh Waqf properties are by user and they'd be wiped out by this law. He also cited the Supreme Court's own Ayodhya judgment, which had recognized the legitimacy of waqf by user as a historical and valid concept. As the day's hearing ended, CJI Khanna expressed concern over violence in West Bengal, reportedly linked to protests against the Waqf Act. If the matter is pending here, such violence should not take place, he warned. On this, the Solicitor General added that pressuring the legal system through agitation was a disturbing new trend. The court was close to dictating an interim order, but SG Mehta requested more time to present the government's view. The matter will now be taken up again on April 17 at 3 p.m. The bench will also decide whether to continue hearing the case itself or refer it to a high court. For more updates, keep watching the Indian Express.